Okay, so this is going to be the 6th of 8. Thank you for sticking with us. Next one is November 14th, and that will be on James Joyce, no, not James Joyce, John Joyce and Peter Mathias. It will be starting a race-based set of trials, 2 trials. One will be in Philadelphia. It will be on fugitive slaves who self-emancipated themselves, committed a murder against a white storekeeper, and we'll start to examine how race is handled in 1808. And then the fugitive slaves will finish off another fugitive slave case will finish off the series, and that took place in Chester County. Both of these have been published through the auspices of the Historical Society of Pennsylvania. They run 2 journals. You can't make a mistake with them because that's going to be like the standard, right? So all the details have to be pitch perfect. So those 2 will be rather interesting and very detailed. And based again on regional archives, so that's of interest to us. So I have had questions asked about what does the title mean, and the title actually refers to the defendant and the plaintiff, and they were the memes of the time that described them to the public in the public print sphere. So, Costa, you can do the, I'll give you just a couple of visuals just to get us started. They're called icebreakers. The first, oh, that's not the first one, Costa. Do the next one. Oh, no? What happened? You lost the first one?
No, that's the order.
No, the first one is Death in Philadelphia. You don't have? No? No, that's George Washington's death. All right, go back to the beginning. I guess it slipped out of the sequence. I was going to show you a very, very rare print, which I'm not going to talk about because you'll be disappointed. Okay, so this takes us to the title. 2, 3, 4, 5. You have 5 showing up there, huh? Okay, never mind. Go to the first one. We'll just work with what we got. This is a slide that is dated 1797. No, sorry, 1803 by James Gilroy, who was a very important British printmaker. And it refers to the figure Benjamin Rush, the American physician, who was famous for his heroic bleeding during the yellow fever epidemics, which he claimed to have invented. In this particular slide or print, we have a Dr. Sangrado, whose head is cut off to the middle right, bleeding. John Bull is a figure of Britain, and he's being serviced by, to your lower right, young or little Boney, he's called, that's Bonaparte, who is, in other words, this bleeding doctor is bleeding England, and it's in the favor of Bonaparte. So it was a widely known theme, this idea. It came from a famous novel of the time by a Spanish author, and it was called Gil Blas. And the doctor in that novel was called Dr. Sangrado. Okay, we can go on to the next one. I'll talk more about that as we come up and talk about Benjamin Rush, but that's supposed to refer to his bleeding process. This is a caricature from 1796 about Porcupine. Porcupine is the figure that represented the journal, the newspaper that was run by William Cobbett, who now will be the defendant, Benjamin Rush having been the plaintiff, Dr. Sangrado. And in this, we find a lion to the right center, representing Great Britain. And above him, we have the figure of the devil, which will come to be associated with him, and which is why we call him the cloven foot. And that language, the cloven foot, comes out of the trial, where 4 times he is referred to by the prosecution as the cloven foot, the hoof of the devil. And so the lion, England, is saying, "Go on, Peter, my friend, and I will reward you." William Cobbett came from Ireland and was considered a British journalist, but he had to escape England, and he had to escape from France, where he went as an emigre because of his publications. So he came to America and did the same thing again. He was an extraordinary political figure as a journalist. He was a Federalist, and the Federalists had passed in 1798 the Alien and Sedition Acts, which were Federalists' efforts to punish, jail Republican journalists. And in this trial, we're going to find the Republicans getting their revenge by using the Alien and Sedition Acts to punish William Cobbett, the Federalist. It's very ironic, and it'll show up in the trials. So the devil figure then refers to the cloven foot, porcupine to the journal that is run by William Cobbett, the lion to England, and the devil says, "More scandal, let us destroy this idol, liberty," referring to the American liberty. Okay, and we can look at the next one. This is the site of the actual trial itself. If you were to enter Independence Hall with your back to the Constitution Center, to your right would be this courthouse, which is the courthouse for the Pennsylvania Supreme Court, which is the court that is going to try this case. Pennsylvania Supreme Court was very important in this period because the most important trials that occurred in the early Republic in the last decade of the 18th century occurred there, when Philadelphia was the capital of the state and the capital of the nation at the same time. So this was going to have a wide reverberance across the nation in this particular case. To your left, you'll see a jury box. To your right, you'll see a piece of the jury box. The jury sat on both sides, and the point was that they should be intimate with the bench, and the bench is that line that goes right across and through the gate, the cage, which is where the defendant must stand. Outside of this barrier here in front of you will be a large open space which was packed with observers. There's no television, right? And except for George Washington, everybody else was very timid about attending the entertainments, which were theatrical performances and circuses in Southwark, which is what we now consider South Street. It was considered immoral. So they just loved to go to trials, and they used to go to anatomy lessons. If any of you know the Pennsylvania Hospital on 8th and Spruce, the very top of that building has the original autopsy and operation room that Benjamin Franklin, who founded that hospital, had designed into the operation of that hospital. People would go there, pay for tickets, and watch operations. They even have a mallet sitting there on the table, which is early anesthesia, right? So trials and medical operations were the biggest form, and hangings were the biggest forms of entertainment. And large crowds came. I mean, they spilled out of Independence Hall, and they filled the mall. And they would shout and scream to cheer on the prosecution or the defense, depending on who they were in favor of. So in this case, we're going to have Republicans against Federalists. Federalists are the party of the elite, and the Republicans are the party of the rowdier lower class, and led by Thomas Jefferson on the one hand, and by Washington and Hamilton on the other. Okay, Costa. And the kind of trial we're going to see is going to be a very rowdy style trial called the altercation style. We'll talk about that again in a minute, but the idea is that that's the client in the middle. He's trapped in the net of law, as you can see, from his belly to his feet. He's being pulled right and left by prosecution and defense who are warring over him. And what says on the bottom partially is, "O glorious uncertainty of the law, the defendant pulled from either side by lawyers for the prosecution and defense. With subtle cobweb cheats, thou art catched in knotted law-like nets. The more they stir, the more they're tangled, and while their purses can dispute, there's no end of the immortal suit." In other words, as long as you can afford your lawyer, that suit will go on ad infinitum. The Bleak House, I think it's Bleak House by Dickens, yeah. Gives you the immortal suit that goes on for generations. Well, this is the American version from 1786, this print. Okay, and the final one is going to give you an idea. We have not had enough yet of George Washington, so this is the last time you're going to get to see him. Enjoy it. Unfortunately, he's going to die in this one. This is his deathbed scene, and he's attended by 2 doctors. But the doctor who was actually blamed for his death was Elisha Dick, and he was a student of Benjamin Rush. And he recommended bleeding. Washington was bled of more blood than exists in the human body as part of his treatment for his respiratory ailment. That was Benjamin Rush's heroic bleeding theory. Dick was his student. Washington died on the day that the verdict was delivered in the Rush v. Cobbett case. So Rush won the case, but he lost the public's support because of this. And so this is the death scene.
Linda, were any of these published in the newspaper?
Yeah, I don't follow print history, but you know, it's a color print, and they didn't do color. That's one thing.
The one with the guy in the net.
Oh, that one. No, they were more. Those were they were handbills, and they used to be sold, you know, like penny novels on the streets, and they would be distributed that way. Yeah, that's an interesting subject, but I haven't studied it.
At FDR Library, they keep the copies of the cartoons, the political cartoons that pertain to FDR.
Oh, that's interesting. Okay, so we have done that. The one I didn't show you was going to be a deathbed scene that was specific to the yellow fever of 1797, which is the subject of this trial. And it was going to show you the doctors fighting over the body of the yellow fever victim, much like the lawyers were fighting over the body of the defendant in that other print. Okay, so let me talk to you now about the case, just to give you some background. First of all, this is an interesting case because you're going to get an opportunity to look at the intersection of law, medicine, the press, and religion as they all inform the case. 18th century, there was very little discrimination among disciplines. They all fed into one another. In fact, we don't have a medical profession or a legal profession until the 19th century. So people would just go to college, and then they would either become doctors or lawyers, whatever they wanted. But they would have basically the same training at the university, if they went to university, or they could simply become apprentice into either medicine or law. But this trial and its text is going to give us an opportunity to see how much interface there is between disciplines. We are now moving out of the area of common law, the early trials we studied, which was basically inherited from the British and had to do with the case law or judicial decisions that were reached in courts, but also statutory law, of which there was much less in England, and which wasn't really brought over into the United States because It had to be appropriate to the circumstance and had to be adopted by the colonies in order to be applicable in American law. So very little of statutory law was actually adopted. So we basically were relying on English common law or case law, which were judicial decisions. And then we moved on to constitutional law, which is what we dealt with in the Whiskey Rebellion trial, whereby we had become a constitutional democracy, and our laws, which would be legislated, our statutory body of laws would be based on conformity with the Constitution. So we always refer to the Constitution and its laws, but what we really mean is constitutional law and statutory law. So we got constitutional law last time around. We hadn't built up a body of statutory law yet because the legislature was trying to pay the war debt, among other things, and very few and far between were American statutes. Well, now we have American statutes. So this is going to be a case on statutory law or legislative law, and in particular, the Alien and Sedition Acts, there were two of them, which were to control the American press, which had gotten way out of hand, and was libeling important political figures who were now losing respect in the eyes of the public, and they felt that nobody wanted to run for office. So the best thing to do was to curtail freedom of the press. And we can look at press law later to see how they did that. So Rush was a leading Republican, and Cobbett was a leading Federalist. So we're going to get a political contest here in this trial. Cobbett had libeled Rush in his publication, The Porcupine, and he had done so by making fun of his bloodletting theory. In particular, he had called him a sangrado, which is the name of that fictional bleeding doctor, and that term had wide use because in England, the translation of Gil Blas, which was Alain René Lessange's novel called The Adventures of Gil Blas of Saint-Hilaire. Since 1742, Tobias Smollett translated it in 1749, but in 1742, Henry Fielding, in his Joseph Anderson, had a character he referred to as a sangrado, and Smollett in his Peregrine Pickle in 1751, that's a wonderful title. He had his title character, Peregrine, treated by a disciple of Sangrado, who scarce left a drop of blood in his body. So it was a term of a widely dispersed term and well known, and it had a very clear referent. So when Cobbett, in his paper, referred to Rush slaying more patients than Samson slew Philistines, that had a lot of bite. And that drove Rush to challenge him in court because it undermined his medical practice. All right, in this particular case, I want to go back just a second and say something about the background. Yellow fever had appeared in Philadelphia from 1648, and it continued in the years 1741, 47, 49, 1762, 65, and then 4 times from 1793 to 1799. If you're following that orally, what you ought to be hearing is that first it was 50 years apart, then it became 28 years apart, and then all of a sudden, the whole decade of the 90s was nothing but yellow fever, which meant that the government in Philadelphia, now this is the period that it's the national capital, has got to routinely evacuate the city. So Washington and Jefferson and Hamilton and Knox and Randolph, where did they come? They came our way. They set up in York, but more they set up in Germantown. and they operated out of taverns on Germantown Avenue in Plymouth. Jefferson he got there too late, he couldn't find a place to sleep, so they put him in front of the fireplace. I don't think the Federalists were too unhappy about that. So there was very little clarity about how medicine was going to treat yellow fever. Physicians disagreed. There were two medical associations in Philadelphia. One ran out of the College of Physicians, and the other, I think, called the Academy of Medicine. They disagreed on treatments. There were French doctors who had come up, like Jean Devez from the Caribbean, where the yellow fever was initiated. They had very conservative ways of treating. They basically treated the symptoms and let people heal themselves. There was Dr. Stevens, who cured Alexander Hamilton of yellow fever. He used a conservative methodology. But Rush was a bit of an egotist. To tell you what kind of an egotist he was, during the Revolutionary War, he was in the medical department of the Continental Army, and he agitated to have the Surgeon General of the medical unit, his name was Shippen, William Shippen, agitated to have him cashiered because he disagreed with the way he ran the medical department. That was a big deal. Rush finally had to leave the medical department, and Shippen was maintained as the Surgeon General. You will be interested to know that a man named Edward Shippen was the head of the panel on the Pennsylvania Supreme Court that tried Cobbett. So he's not necessarily going to be Rush's best friend. Shippens were a very important family in Philadelphia. So there's all kinds of connections because people know each other. It's a very small world in Philadelphia. Even though the lawyers that we're going to see in this case, we will have seen them before. I won't routinely refer you to where we knew them from, but their names keep coming up again and again in different combinations. You know, sometimes they might be for defending a Federalist or defending a Republican in another case. It's a very mixed bag, but they all knew each other. They all shared legal notes with one another because there were no printed law reports during this period. If there was any transcript of a trial, it was because it was privately printed, because it was a scandal, or it was a moral exemplar, and it was printed by priests or reverends or whatever. So, we have everybody fleeing the city, including the government of the state of Pennsylvania, the government of the city of Philadelphia, and the national administration. And the city is left to its own, and it will now be run by citizens of Philadelphia, the Northern Liberties, North Philly, and the District of Southwark to the south. They will get together and they will organize a fever hospital in Fairmount Park. They will declare a yellow flag law, whereby any house which is suspected of having yellow fever, a yellow flag will be put up on it. And people were so terrified that they would be associated with someone who had yellow fever, and they would be thereby carted off to the yellow fever hospital, which was a pretty terrible place. That there are accounts, multiple accounts, of people throwing their sick relations out of upstairs windows onto the street to be picked up. I mean, they weren't even dead yet. Hard to think of, but nonetheless true. Surrounding towns refused to allow anyone from Philadelphia to enter their districts. They refused their products, their refugees. They isolated the city from the rest of the world. Lancaster and Massachusetts, Lancaster County and Massachusetts were the worst. We have examples of the proclamations they put out forbidding Philadelphia citizens to come into their area. They rejected their baggage. They required all kinds of detention and quarantines and so on to prevent the infection from spreading. And now we come to looking at the issue of how yellow fever was actually treated. If you were a patient of Dr. Rush's, you had a better chance of surviving the fever than surviving Dr. Rush. The fever only took 10% of the population of Philadelphia. What was his treatment? It was deservedly controverted, and it attracted a lot of commentary. First of all, he used what are called clister pipes. Clister pipes were like big needles, right? But they were used as an emetic, right? So they could give you an enema using these clister pipes. They purged you with ipecac to make you vomit. They induced profuse sweating. They created blisters, by cupping the skin. And then they would use laudanum to subdue the effects of vomiting and purging and extreme bleeding, because they would cut the veins. And Rush acknowledged taking blood 12 times in 6 days from one patient, at least 140 ounces, 60 of which he took in 24 hours by 5 bleedings. That's an awful lot of blood. And I have to say that in many cases, over the 4 days, he depleted the human body of the, 15 pints of blood that it contains. So when they say heroic bleeding, they really mean it. He refused to change his practice. He was the most prodigious teacher of medical students in the country. And so all of his students were trained in heroic bleeding, which meant that whenever there was a yellow fever epidemic, it was more likely that if you had a physician who would stay in the city to treat you, he would be a student of Rush's. So he's a really very stubborn man. He was much deserving of Cobbett's comments about him. But nevertheless, he was never tried for malpractice. There wasn't a single malpractice case against Rush. He's written on it in his lectures to his students. He wanted to make sure that his students didn't get accused of malpractice either. So he trained them in that as well. First, under malpractice law, once one voluntarily put oneself in a physician's care, it was difficult to claim force. He couldn't interfere with your person if you had agreed to the treatment, and by virtue of putting yourself in his care, there was an understood agreement to that care. If a physician was to be charged with malpractice, the most frequent charge would have been that he defaulted in the discharge of some customary duty incident to a public calling. Well, if you listen to the last part of that, incident to a public calling, what if you never subscribe to the idea that you are a physician, but you call yourself something else, like an empiric, or a quack, or a piss pot doctor? There used to be doctors who would walk around with piss pots, and they'd cover it with a cloth, and they would study your urine and your excreta to smell it and so on, and then they would diagnose you. It's a very interesting period. But so long as you didn't call yourself a doctor, you weren't held accountable under the law for being responsible to meet the standards of the common calling. Another problem was that physicians disagreed with one another. So if there is no agreement on treatment, how can you say there is a commonality of care to which any physician would have to subscribe? So they couldn't get them on that either. There's a political aspect to this as well, because as one period source says, the inexperienced and the unlearned attend to surgery in their way or is not attended to at all. Well, that means that in the rural areas, where you're very unlikely to have anybody who's been trained through the College of Physicians of Philadelphia or any other modestly professional group, the surgeons who are not very proficient will be in the rural areas and will have no medicine whatsoever if they're going to be accused of malpractice. So that political aspect of it kept malpractice cases under the radar. There were very few and far between, and they were never successful. Why weren't they successful? Because patients were required or expected to choose a provider of good judgment. And if there is a poor result, and the quote is, it is fairly to be attributed to his own mistake. He made the choice, right? So a free or open market in medicine meant that caveat emptor, let the buyer beware. It was the patient's responsibility, even if competition and predation on the part of practitioners would lead them to a bad choice, it was still legally their problem, and they bore a burden of proof. So they had to prove that they had not been non-compliant with the physician's recommendations, and a physician can simply make the case that I told him what to do, he didn't do it, right? Or he did it too late, or he did it too little. So physicians had that defense in their hands. And again, the patient, having chosen the physician, had in effect consented to the injurious or deadly treatment, which left him further at risk. And that was a presumed waiver of liability as far as the physician was concerned, or at least shared responsibility between him and the patient. And that undermined the ability to, for malpractice cases. Cobbett really faced a very hard time if he was going to make the case that Rush was guilty of malpractice, and that, in fact, he, under press law and libel law, was justified in that his was by a truth defense. In other words, given the facts, he did nothing but tell the truth. And sedition law, alien sedition laws, allowed that as a true defense. But for all the reasons that I just mentioned, it was going to be very unlikely that he could rely on the facts of the situation because there were so many complications inherent in it. Moreover, under Blackstone's principle, this is under common law, but it was carried over into American libel law, you cannot prevent the press from, that is, prevent them ahead of time, preemptively, from publishing. So there you have the freedom of the press. But the freedom of the press does not obtain after the fact. After you published it, then you can be taken to court. So that limits the liberty of the press. So the liberty of the press and the freedom of the press are at odds with one another under a libel law. So justification of truth was no defense for Cobbett. And what he was left with was what's called the privileged occasion. There were two defenses, one being, was it true? The other was the situation such that in the free marketplace of ideas, the press is required to raise the alarm for the public? It was a privileged occasion. And could he get out from under on those grounds? That was the defense that he would choose. That people were dying, this practice, this heroic bleeding practice, was widespread and deadly and was undermining the health and safety of the city, and that he did no more than raise the alarm, and that he had a right and a responsibility to do so because the medical community itself was split in terms of what treatments to use. And they were warring among themselves. How was he any more guilty than they in terms of raising the alarm when they were already having a press war against each other? So that was the defense that he was going to rely on. He did not rely on a defense whereby he would attack Rush's person. Rush was a very privileged person here. He was a Republican of great repute. He was widely honored among Republicans, and Philadelphia was a Republican city. So he had determined that although he had been involved in feuds with all kinds of other physicians, he was a very erratic and irascible man. He had made a lot of enemies, certainly in the medical community. He had split the medical community right down the middle, so there were There were a lot of physicians that would happily have testified against him if they could have gotten away with it. His sons were responsible for fighting duels and running their own feuds. They were, beating men up on the streets with canes. We had a lot of cases that are involving his sons. And then there was this famous case where he tried to have a court-martial of William Shippen during the period of the Revolution. And he actually, in the process of doing that, he joined what's called the Conway Cabal, where he and a number of other officers in the Continental Army tried to replace George Washington with General Gates. So there are a lot of reasons why he could have, he had a lot of good arguments to make on behalf of undermining his character. But he decided that he had so many of his own problems and so many suits that he was running, and he was involved in so many press wars with other journalists that, raising a scandal against Rush wasn't going to do him much good because they could raise the same kind of arguments against him. So that was taken off the table. So what did the other side, that is Rush's side, use as arguments in their behalf? Well, basically, their argument was, first of all, that they had probably the best lawyer in the city on their team. Interestingly enough, it was only his first case. But this guy was good, and they took a chance on him. They had some other top-notch lawyers on the case, but they gave him his head, and as it turned out, there were 6 lawyers, 3 on each side, and he went first. Every other lawyer who argued in reference to the case that he made in his remarks. Well, that's already for the jury going to be proved dispositive, because there's this kind of, vibe that you get. The other lawyers are respecting and honoring his argument in that way. What does that tell you? Interesting is the way, I'm going to go back to how they argued the case in just a second, but I wanted to show you something about what I started to say about altercation trials. The way that trials used to be run up to the 19th century were called altercation trials. It was a lot like, let's see if I can give you a good example. Okay. It's a lot like, fighting in public. Everybody's standing in the well of the courthouse. Somebody's trying to read their argument. The judges on the bench are chit-chatting among themselves. Another lawyer from the other side gets up and is trying to get himself heard. They're arguing among themselves. Somebody on the bench hears something they don't like, starts to scream at the lawyers. The crowd is roaring in the background and cheering the lawyers on. This is what's called the altercation style. You're not familiar with it because it didn't survive. Yeah. An aspect of the altercation trial is that lawyers don't have clear places where they make their arguments. For example, you don't have the prosecution and then the defense and then they do their summations. Under an altercation system, they're not allowed to address the jury. So all they can do is fight with each other. Meantime, the judge is interrogating witnesses. They're not allowed to do that. They can cross-examine a witness that the other side brings up to the stand, but they cannot do what the judge is doing. He has the freedom to interrupt them, and the lawyers have to speak in whatever order the judge allows. So in this case, I'm going to say P for prosecution and D for defense, okay? So it's P, D, D, P, D, P. Now, if you're in the jury and you're going to hear them in that order, I defy you to figure out what either side is saying, or to pick a winner, even, right? Except that prosecution, if you heard that right, it goes first and prosecution goes last, and the defense is sandwiched back to back in the middle. So they were going to get dumped on no matter what. You know, it's going to be almost impossible for them to make their case. And they realized that. So they decided not to argue on the facts of the case. Because they figured no one would remember it. Moreover, Hopkinson, at the beginning of his argument, made a case based on abstract principles, this kind of a debate between good and evil, the Satan against the virtuous man, you know, all kinds of abstract art. And why is that? Because this is the period of high rhetoric in the law. Lawyers had just started coming into their own. Prior to the Revolution, it was judges who pretty much dictated what would happen in a courtroom. After the Revolution, lawyers were greatly honored. This is probably the only time in history when they got, you know, a fair shake. They were greatly honored because it was lawyers who put together the Declaration of Independence. It was lawyers who argued at the Constitutional Convention. It was lawyers who argued at the Ratification Convention and who wrote the Constitution. So now in the courtrooms, people are hiring lawyers, right? And things are starting to change. An adversarial system is developing. Judges are losing power, and juries. So there are some arguments that in the colonial period, juries had more influence than judges because they could judge on both the law and the facts. Juries could, not just the facts. But then judges were doing the same thing. Plus, judges were relying on the fact that it was their courtroom, right, to make a direct charge to the jury as to what verdict they expected them to deliver, and if they didn't deliver it, they would send them back. Now, you would think that wouldn't make a big difference. But up through the end of the 18th century, you are not allowed to have a bite to eat when you're sent off to deliberate. And there were guards that were there to make sure that you didn't eat anything. Believe me, that was a good incentive for the juries to want to give the judge's verdict. But nullification verdicts were very frequent during the colonial period because judges were appointed by colonial authorities who were appointed by the English, right, in 13 colonies. So that was their only way for a common man jury to make a political statement in a political case that had come to court. So this is not what we expect, right? But when lawyers come into court in droves, in a famous case like this, and start to make arguments that are exciting, not just inciting, they did incite riots and, you know, crowd behavior around cases, even rescues of prisoners because their arguments were so inciting, but they were exciting as well. They based a lot of their rhetoric on what was happening in the churches. So it had a lot to do with Armageddon and, you know, if you don't vote my way, the world is going to fall apart. There were Jeremiah, you know, Jeremiah's kind of things about we've been blessed by the Lord and we owe the Lord and give me the verdict, you know, because I'm on the side of the Lord. This is the kind of arguments you got. They're beautiful, you know, but we call it what we call purple rhetoric for a good reason. It was very florid, very you know, over the top. But there was an aspect of the prosecution's arguments which is worth noting, because if they did have a case, if they were trying to make a case based on anything that looked like law, it was where they talked about property. So here's the argument that they used that they thought was legal. A man's private reputation is a form of property. Okay, so there's this assault on Russia's reputation. It undermines his business. He's not getting patients. So his private reputation is a form of property. Character is the grounds on which reputational capital is based. So now you see reputational capital becomes, it's a form of exchange, something like money, right? It's your income, it has to do with the economy. All right, so now you got property law and you've got reputational capital, which undermines his livelihood. Character, therefore, deserves the same protections as property. It's a very bad syllogism, but it looks like it's borrowing from and relying upon property law and associating libel law with property law to get a kind of legitimized verdict. But what was the other kind of things that they were... Okay, I am aware that I did it wrong last time, so we did start 15 minutes earlier today so that we would not run up against the dinner hour. The other kinds of arguments they were making had to do with virtue. So they posited Rush, the prosecution posited Rush as a figure of virtue. He was a father and a husband who defended family honor. What's the distaff side? Cobbett was a violator of family honor. Rush was a patriot and a Republican who defended his country's security. Cobbett was a foreigner. Rush was a self-sacrificing citizen, physician, Hippocrates, who played the role of the savior of the city. Cobbett polluted the political center of the nation. These are lines that I'm taking from the what was actually delivered by Ingersoll, Levy, and Hopkinson on Rush's behalf. So with regard to the virtue argument, is the virtue of the injured, now this is Rush, to be the defense of the injurer? That's the question that's raised by the prosecution, Rush's lawyers. In other words, Cobbett had nothing much to go with. So he said, look, I'm a nothing. You know, he didn't say I'm a foreigner because then they think he was a spy for England, so he wouldn't admit that. But he said, I'm not all that important. And I can see the benevolence of Benjamin Rush. I can see the reputation he has as a great man in the city of the Philadelphia. How could I possibly have hurt him? How could I injure his reputation? Certainly his fellow physicians from these other, these other treatment areas and from these other academies who disagree with him, they could have hurt him, but me, not so much. So they were conceding that his virtue was such that there was no injury. The prosecution comes back and says, is the virtue of the injured, is Rush's virtue, going to be Cobbett's defense? He's going to get away with it for that reason? And then they ask this question, which is typical of Hopkinson, this fiery young lawyer. Have you a daughter of spotless virtue and discretion? Is there then no offense to proclaim her a prostitute? Nothing was out of bounds for these guys. Okay. So finally, because I had said something about the clove foot in my title, here's the quote from the prosecution that brings that into the trial. If the clove foot is discovered, if the veil is seen through, if the disguise is discovered, in other words, Cobbett has represented himself as not all that influential, as a man who was only trying to raise an alarm for a city which was diseased and its people were dying, and he was trying to, argue on behalf of safety and health. So he says, if that's his disguise, and we discover it, the law shall strip the sheep's clothing from the wolf and expose him in his own natural deformity. So that language of the clove foot being discovered is repeated by each litigator on Rush's side until that theme then becomes embedded, right? I mean, if you hear it, the first thing you hear, you get the first word. The last thing you hear, they're the last ones to argue, they get the last word, right? Those are the two places where the jury will be paying attention. So, and by the way, they get another shot right in the middle, in case it's too long for you to wait from beginning to end. You can see what the defense had to come up against. They really didn't have much of a shot. And then finally, they use the image of Mark Antony and Julius Caesar from Shakespeare's play. And they actually quoted from it. They claim that Rush's case was like Mark Antony's defense of Caesar, right? He is an honorable man. I'm not here to defend him, but is he not an honorable man? And they keep going back and forth like that. Cobbett's defense comes forward and tries to match that and says, it may be like Antony and Caesar, but here we have an ambitious Caesar, Rush, cut down by the wounds of the brave Brutus, Cobbett. And so they turn that image on its head. Maybe you're getting the idea, but there's a great deal of what's called oppositionality in the argument in this case. The one is a Satan, the other is an angel. The angel operates from the shining city on the hill, which is an image that was used of America during the Revolution, right? And Satan, of course, is that odious force from within the bowels of the earth. And this is the kind of language that you see in the arguments in the case. Okay, so far, we're not doing too badly. We have looked at the arguments, we have looked at the law. I've given you a little bit of background on the yellow fever epidemic. And I've talked to you a little bit about altercation trials and what they are like. But going forward, there will be a change, a switch. Remember, we're doing this now so that we can move on to the next trial, to what's called the adversarial system, which is what you're more familiar with. But how you get from altercation to adversarial trial is not a necessarily simple leap, and it's not merely aggregative. It really is a very clear difference, and it has a lot to do with the diminishing influence of judges, the stabilization of juries, and the increasing importance of lawyers. And as this is working itself out, and it starts to work itself out just before the Revolution, and it takes it all the way well into the 19th century to stabilize itself, in conjunction with the professionalization of the law itself. In other words, law was not considered a profession. They did have a bar in the 18th century, and you had to pass the bar. But passing the bar was simply apprenticing with somebody who was already a lawyer, who had some influence, and would sign a piece of paper for you. To get into a club, it was more like a guild. But when lawyers became more and more prominent, you needed to professionalize the law. We started to have legal treatises being written by Americans. We didn't have that until the, again, 19th century. Law schools didn't come into play until the 19th century, right? And the bar, once you have law schools, now there's a real test for being a lawyer. So with that professionalization, you have now the beginning of a regularized court, and that regularized court will operate as an adversarial courtroom. So what is that? Well, the first thing that happened to get us there is that rules of evidence started to be developed. All these trials that we've been studying have been run without rules of evidence. And now you can challenge witnesses, you need to provide proof, lawyers can insist upon corroboration of testimony, they can challenge confessions, they can assert refusal to answer questions based on self-incrimination. The burden of proof will now shift to the prosecution. You can see all these things starting to happen over time. Reasonable doubt will come into play, so that by the time it's all worked out from before the Revolution until first third of the 19th century, by the time we're finished, we will have the adversarial system. And as I said, the judge will no longer be able to interrogate witnesses from the bench. He will no longer be able to judge both the law and facts. He shall only apply the law. The jury shall no longer be able to decide what the law is that should be applied. It will only be able to judge on the basis of the facts. So now everybody has a proper role. You saw from the court martials when we studied them what that was like. Well, when you get to the adversarial system, which is what we'll see in the next two trials, it's going to be a lot calmer. It's going to be a lot more rational. I'm going to argue that you're still not going to get much more justice from it. You'll get a whole lot more law that will make sense, right? And you can read it, because you can read the law now, because the legal decisions of these court cases will be memorialized in official law reports that are published by the state, which we will not have had up till now. Okay, I see Richard is coming again. It's quarter after. And
I wanted to leave a couple minutes if anyone had any questions. But I had a basic question, and that is, in this transition from one type of practice in the courts to the other, was there any difference between the civil and the criminal cases?
No, actually. Let me say that there was also no difference between trial courts and appeals courts. This court that we're looking at is the Pennsylvania Supreme Court. It should be an appeals court. It's running a trial. It should be trying criminal cases. It tries both criminal and civil cases. So, and by the way, if there's an appeal to this case, guess what court it's going to go to? Right back to the same court. Let me give you just a quick idea of what it would look like. There's a case called the Yurujo case, Y-R-U-J-O. Turned out he was the prospective son-in-law for Chief Justice McKean of the Pennsylvania Supreme Court. In that case, he was assaulted by Cobbett, that is in the press. He was the minister, Spanish minister to the U.S. So the Chief Justice decides to prosecute Cobbett. He brings charges against him. He brings charges against him in his own court. Well, he will preside as judge. And while he's judge, he will step down from the judge's bench, give witness testimony against him, and then step back up and adjudicate the case. And in his charge to the jury, he'll say to the jury, I brought these charges against William Cobbett, and I expect you to do your duty as good citizens. That's what was going on.
Well, I'd like to ask, does anyone have any questions for Linda? You're all either dumbstruck or asleep.
Don't be afraid, I made a lot of mistakes.
Yeah. I think Lincoln, he didn't go to law school, he just read books, and did he pass the bar? I mean, it seemed like a kind of an informal apprenticeship kind of process by which he became an attorney.
I don't know about Lincoln, but remember he was in the middle of the 19th century, and there was now a profession called the law. But if he was in my century, I now am in this century, he would have simply had a patron who would have brought him along. He would have apprenticed under him, and then he would have made sure that he slid into the, under the bar by virtue of the bar and become a lawyer. It was very simple. We had a question over here. Richard, okay, I'm going to answer yours anyway. What was your question?
Was this going on in all the...
Yeah, so the question is, what I've described in Pennsylvania, did it go on in all the states? And that's a big question. How representative of the United States, of the other states in the United States, was anything that happened in Pennsylvania? So I just finished a book manuscript where I make the case that I am studying the early republic through the 8 cases that you and I are suffering through in this series. And that's now at Penn State University Press. And I had to justify to them why we should just study Pennsylvania cases and then say this was characteristic of the early republic, which would mean the other states. So I made that argument, they bought it, but my argument was that it was the center of what was going on. The 13 colonies were operating under English law, so they had courts that were comparable. On the other hand, you have the Puritan system of justice in Massachusetts. You have the influence in Maryland of Catholic, ecumenical, not ecumenical, I think is the word they use, courts in Maryland. And you have a Quaker influence in Pennsylvania, right? And in the South, even where they have British influence in their courts, or they were colonies that were founded by, like in Virginia, by the British, to what extent are they alike? Because slavery in the South would change radically the kind of law, right? Because they would use legal codes and not statutes. So there are two sides to this argument, but the most recent scholarship that has studied the colonies in a multi-volume study by William Nelson makes the claim that there was more commonality than dissimilarities, and his proof of that pudding is that they all got together to fight against the British in the Revolution. So whether that's a good argument or not, that's where it is right now.
Is this on? No? Okay. You didn't say, I don't remember that you said anything about the juries in the cases. You talked a lot about the prosecutors and the judges. Could you say
About this particular jury?
Mm-hmm. Or
Okay.
juries in general?
Oh, juries in general. There's not too much evidence on this particular jury, except that, as we have seen before, the ability to have a struck jury, meaning that you can use all of your challenges to the jury, right? And there were 36 challenges you could use in the last case, right? Pretty much then you can get a more favorable jury as you go through the jury pool of 72 people to get to your 12. So that's one way of picking a jury. But a struck jury is where you have some discretion on the part of the judge, and you don't use the normal jury pool, you use a special jury pool, right? Well, that was what happened here. They went through 7 iterations of struck juries before the judge, McKean, he wasn't on the panel that tried the case because he was elected governor right then and there, and he had to get off the bench for that one. But he was in the process from 1797 to 1799 when they were choosing the jury, and 7 times he delayed the case because they didn't get the struck jury they wanted. Finally, when he could strike a jury that he liked, remember it's supposed to be chosen by the defense and the prosecution, but when he finally got the struck jury he liked, that's when he allowed the case to go forward. So William Cobbett had to wait 2 years to be tried on those charges. And you have to know this, that while he was waiting, he was under a peace bond. This is something that William Penn's government gave us. That is, without ever being charged, you can be put under a restraining order that you can't commit any particular conduct the judge doesn't want you, he can't publish in this case, right? Anything more against Benjamin Rush. So Benjamin Rush's team liked the idea that Cobbett, the trial was delayed 2 years because they were home free, but Cobbett didn't play the game. He published anyway. So while you've got this, we're still striking the jury, McKean comes along and he charges him with violating the peace bond. Right, now, so you got this trial going, right? You've got the Araujo case going over here, remember, against the son-in-law, future son-in-law? And now McKean's got his hand in the mix and he's got him on a peace bond. Peace bond means you got to put money down. It was financially debilitating. All right, plus you're liable, with no charges against you, mind you. Even if, as happened with Cobbett, he was found not to have violated that peace bond, right? And therefore, it was adjudicated that he was released from custody. They put another peace bond on him, even though he had been acquitted. So you can see, I don't know what the question was anymore.
Okay, my question is very simple. What happened to Rush? Did he have to stop bleeding people to death?
Oh, and then he didn't have to because physicians were not licensed until the 19th century.
So what happened to the case? It just went on and on and on?
No, he won, and it was $5,000 fine against Cobbett. Cobbett fled to England, didn't pay the fine. Russ's reputation was ruined because Washington died on the day of the verdict, and they blamed it on Eliza Dick. And he, not that he died in ignominy, but he was not well respected thereafter. So he was a Pyrrhic victory, right? He won the case, but his reputation was destroyed. Yeah. There's a
Thank
picture all the way behind him. Yeah. And don't worry, David, if it was a simple question, I would have complicated it if I could have.
I'm absolutely astounded at your scholarship. I can't imagine how you did all this research. The primary sources, if I understand you correctly, were not reliable. There was no official record. And the press really said that they won, right? And there must have been written accounts at the time, and even in the courtroom, people who were there, but everybody had their biases. I can't imagine how you put all this together.
Yeah, I'm exhausted. In this case, I got a little help from my home institution, which was Westchester University, because there was a judge from Chester County in Darlington, and he donated his papers to Westchester in a special collection. Well, as faculty, I had access. And I found among his papers a transcript of this trial by somebody named T. Carpenter, who had been sent to the trial by his printer to surreptitiously take down the case, and then they printed it and they made a lot of money out of it. Well, Cobbett raised that as an issue in the trial and said that, you know, that was a setup, and the transcript was written to Rush's credit, and it was done to do him in, and so on. But in this case, I lucked out a little more than certainly in the George Washington case, the land case with George Washington was a horror show.
Well, Linda, thanks very much. Again, the next in her series is November 14th, and we look forward to seeing you then.
Yeah, thank you.